They told you a green card meant safety. They told you permanent residence was your protection. But right now in 2026, thousands of green card holders are being put on planes and sent back to countries they haven't lived in for decades. And here's what's terrifying. Most of them had absolutely no idea this was coming. I'm George, and on Dream Visa Updates, we don't sugarcoat what's happening in immigration. We tell you the truth, and today's truth is critical. In the next few minutes, I'm breaking down exactly what triggered this deportation wave, who's being targeted first, what the actual new rules say, and most importantly, what you need to do right now to protect yourself. If you've ever held a green card, if someone in your family has one, or if you're working toward getting one, this video isn't optional. This is survival information. I'm going to tell you things that most immigration attorneys are still figuring out. So don't skip ahead, don't close this tab, because the part that affects you most might be the part you least expect. Welcome back to Dream Visa Updates. Let's cut through the noise and get into what's actually happening inside the American immigration system right now. For years, there was a quiet assumption in the immigration system. Get your green card, follow the rules, pay your taxes, don't commit crimes, you're safe. That assumption, it's dead, officially dead. The policy landscape in 2026 has shifted so dramatically that immigration lawyers are calling it the most aggressive overhaul of permanent resident protections in modern American history. And I'm not saying that for effect. I'm saying it because the confirmed deportation orders, the court filings, the DHES memos, they all point to the same conclusion. So what exactly changed? Why is this happening now? The new enforcement priorities issued in early 2026 fundamentally redefine what it means to be a deportable permanent resident. Under previous administrations, there was a narrow set of circumstances where a green card holder could be removed: serious felony convictions, fraud during the application process, abandonment of residency. That was it. The new rules expanded that list in ways that are sending shockwaves through immigrant communities across the country. Here's where it gets unsettling. The updated policy now includes something officials are calling public charge reevaluation triggers. What does that mean? If a green card holder has used certain government benefits, and in some interpretations, even benefits they were legally entitled to, their permanent resident status can be flagged for review. Now, the government isn't saying everyone who used Medicaid is getting deported tomorrow, but what they are saying is clear. Using public benefits is now a factor in whether your permanent residence stays in good standing. That's an enormous shift. And here's the critical question nobody has a clean answer to yet. Where exactly is the line? How much benefit use triggers a review? Over what time period? Which specific programs count? The vagueness isn't accidental. It gives enforcement officers tremendous discretionary power. And discretionary power in an aggressive enforcement environment, that's dangerous for anyone who doesn't know how to protect themselves. But that's just one layer. Let me talk about what is arguably the most documented wave of deportations happening right now. It involves something called status abandonment. This is genuinely shocking thousands of people who believe they were doing everything right. Here's the shift. The threshold for what counts as abandoning your green card status has been aggressively lowered and reinterpreted. Historically, immigration courts looked at whether you spent more than a year continuously outside the United States. That was the primary indicator. That benchmark is now being applied retroactively, and it's being combined with new secondary factors that build a deportation case even when someone returned within the supposedly safe window. What are these secondary factors? Maintaining a foreign bank account as your primary account. Filing taxes in another country, even if you also filed in the US. Having a foreign driver's license. Enrolling your children in school abroad for an extended period. Owning property abroad in a way that suggests your center of life was outside the United States. None of these alone was ever a smoking gun. But enforcement officers are now bundling them together to construct a legal argument that your permanent residence was functionally abandoned, even if your green card never expired. And this is where the confirmed deportations are coming from. People who left during COVID, people who took care of sick parents abroad, people running legitimate international businesses, people who thought they did everything correctly, people who are now sitting in immigration detention or have already been removed. At Dream Visa Updates, we've been tracking these cases since the enforcement memos started leaking in late 2025. The pattern is clear. The enforcement is real. It's accelerating, and it's not slowing down. I know some of you watching this are starting to feel genuinely anxious. Maybe you spent time abroad recently. Maybe you've used government benefits. Maybe your immigration history isn't perfectly clean. I need you to stay with me because the second half of this video is where I give you the actual defense playbook, the things you can do, the documents you need, the moves that protect you. But first, we need to understand one more major pillar of the 2026 rules. It affects a specific group that almost nobody is talking about: green card holders with old minor criminal records. Here's something that's going to hit differently depending on where you are. Under previous enforcement priorities, prosecutors and immigration courts exercised significant discretion around minor, old, or expunged criminal records. A shoplifting charge from 15 years ago. A DUI pleaded down to reckless driving. An old marijuana possession charge from a state where marijuana is now fully legal. Those records were frequently overlooked or deprioritized in deportation proceedings. That era is over. The 2026 enforcement matrix, and this comes directly from leaked internal DHES documents that immigration attorneys have been analyzing, now instructs enforcement officers to flag permanent residents with any criminal history, regardless of how old, regardless of severity, regardless of whether the charge was expunged under state law. This is critical to understand. An expungement under state law does not erase the record for immigration purposes. It never did legally, but it was frequently treated as a practical clean slate. Not anymore. What this means is hundreds of thousands of green card holders are walking around right now with a deportable record and don't know it. They were told years ago their record was cleared. But now, if they trigger any enforcement attention, a traffic stop, a tax audit, a benefits check, a re-entry inspection, they're vulnerable in ways they weren't a year ago. This is why immigration attorneys are absolutely swamped right now. This is why FOIA requests for immigration records are skyrocketing. People are scrambling to find out what their actual exposure is. So let's get into the protection side, because knowledge without action is just anxiety. The very first thing every green card holder needs to do, and I mean this week, not someday, is pull your complete immigration file. You're entitled to your A file, your alien registration file, through a Freedom of Information Act request. This file contains everything the government knows about your immigration history. Every application, every document submitted, every note made by any immigration officer who's ever reviewed your case. You need to know what's in there before they use it against you. Second, and this is especially urgent if you've traveled internationally in the last 5 years, document your physical presence in the United States as thoroughly as possible. Bank statements showing US-based transactions, medical appointments, your children's school records, employment records, tax filings, lease agreements, mortgage statements. Build an undeniable paper trail that proves the United States has been your primary place of life, your center of existence, your home. If your status is ever challenged, this documentation is your defense. The deeper and more detailed it is, the better your position. Third, and this one is counterintuitive, so pay attention. If you have any old criminal record, even something you believe was expunged or resolved, sit down with a qualified immigration attorney and have that record evaluated through an immigration lens, not a criminal law lens. The two systems interpret records completely differently. What looks like a clean record in one system can be a landmine in the other. This isn't optional if you want to protect your status under the new enforcement environment. Fourth, if you use or have used government benefits, document the legal basis for your eligibility and be prepared to explain it. The public charge analysis under the new rules isn't final law in all jurisdictions. It's being challenged in federal courts right now, but that doesn't mean you're automatically protected. It means you need to be ready because enforcement is happening while litigation is ongoing. And fifth, if you're planning any international travel as a green card holder in 2026, consult with an immigration attorney before you go, not when you get back, before you leave, because the re-entry inspection process has been intensified. The questions being asked at the port of entry about your ties to the United States, your activities abroad, your intentions, these questions now carry more weight than they used to. Being unprepared at a re-entry inspection in 2026 is a completely different risk than it was in 2022. Now, let me address something that's creating enormous confusion, a question I see constantly in our comments. Does any of this apply to people already in the naturalization process or who have pending citizenship applications? The short answer is yes, but differently. If you have a pending N-400, that's your naturalization application, USCIS is now conducting more intensive background reviews as part of that process than at any point in recent memory. Cases that might have sailed through before are now being flagged for additional evidence requests. Old criminal records are being discovered and used as grounds for denial, or worse, for triggering removal proceedings against people who thought applying for citizenship would make them safer. There are documented cases in 2026 of people who filed for citizenship, triggered a deeper look at their record, and ended up in deportation proceedings as a result. This isn't meant to scare people away from pursuing citizenship. Naturalization remains the ultimate protection from deportation for the vast majority of people. But it does mean that if you have anything in your background that could be problematic, you need professional guidance before you file that application, not after. Let me address what happens if you receive any kind of notice from USCIS or Immigration and Customs Enforcement. This is where people make catastrophic mistakes. If you receive a notice to appear, that's the official document that initiates removal proceedings. Do not ignore it. Do not miss the hearing date. Do not assume it's a mistake that will resolve itself. The single most common way green card holders accelerate their own deportation is by failing to respond to official notices, either because they don't understand what the document means or because they're afraid and hope the situation disappears. It will not disappear. An immigration judge will issue an order of removal in your absence if you don't show up, and that order is extremely difficult to undo. If you receive any official notice, your first call is to an immigration attorney. Not tomorrow, that day. Many immigration attorneys are now offering emergency consultations, specifically because of the volume of notices going out under the 2026 enforcement priorities. Before we close out, I want to address the political and legal context. I think people deserve to understand what's actually driving this moment. The 2026 enforcement push isn't happening in a vacuum. It's the result of years of shifting political pressure combined with a Supreme Court that has consistently ruled in favor of executive authority over immigration enforcement. The legal challenges being mounted by immigrant advocacy organizations are real, and some of them will succeed. But the courts move slowly and enforcement is moving fast. Waiting for a court to save you isn't a strategy. It's a hope. At the same time, and this is important to hold alongside everything else, not every green card holder is equally at risk. The enforcement priorities, even in their expanded form, are still prioritizing certain categories. Recent criminal history, clear evidence of status abandonment, fraud in the application process. If you're a green card holder who has lived continuously in the United States, maintained your ties, filed your taxes, stayed out of legal trouble, and kept your documentation in order, your risk profile is significantly lower than someone who hasn't done those things. But here's the key word: documented. In an aggressive enforcement environment, the difference between a protected green card holder and a vulnerable one is often simply a matter of who can prove what. The rules haven't changed as much as the expectation of proof has. The government is no longer giving anyone the benefit of the doubt. You have to show your work. That is the world we're in right now in 2026. And the people who are going to come through this period without losing their status are the people who took it seriously, who got informed, who built their paper trail, who didn't assume that having a green card meant they were untouchable. You are not untouchable, but you are also not powerless. And that distinction matters enormously. If this video gave you clarity, if it showed you something about your situation you didn't fully understand before, do two things right now. First, drop a comment below telling me your biggest question about green card status under the 2026 rules. I read every comment. I respond to as many as I can. Your questions directly shape the content we create on Dream Visa updates. Second, share this video with every green card holder you know, not because I need the views, but because there are people in your life right now who don't know what you just learned. And in immigration, information is protection. Subscribe to Dream Visa updates if you haven't already and hit that notification bell because the rules are changing fast. Every video we create is built to keep you ahead of the enforcement curve, not behind it. Stay informed, stay documented, stay protected.